Madam President, distinguished judges of the court, I will now address the violation of Article 3 of Protocol number 1 and Article 13 of the Convention in light of the Court's 2 questions and of the third-party brief of the Venice Commission. It is our respectful submission that even if the ban from election and the stripping of mandate were not to be regarded as criminal sanctions for the purpose of Article 7, such measures would still be contrary to the Convention for the following reasons. First, the interference with the applicant's right to stand for election and to preserve his parliamentary mandate were not provided for by an accessible and foreseeable law or by an adequate level of regulation. Second, the 6 years ineligibility and the stripping of mandate imposed on the applicant are not proportionate to any aim allegedly pursued. Third, there were insufficient procedural guarantees in place so as to ensure a fair and objective decision and prevent any abuse of power by Parliament. Fourth, the Italian legal system provides the applicant no right to any principled review at any point against the application of the Severino Decree and against the exercise of Parliament's discretion. I will briefly deal with these 4 points. First, it is our position that the qualitative requirements of legality are not satisfied in the present case. As explained by my learned colleagues, the Severino Decree has been applied retroactively for the very first time against Mr. Berlusconi in relation to a criminal offence he had allegedly committed some 15 years earlier. At that time, the applicant could not foresee that he would suffer such an extended limitation of his electoral rights and even be removed from his parliamentary seat in the event of conviction. Moreover, we agree with the Venice Commission that the Severino Decree is not an adequate level of regulation for at least 2 reasons. First, because it is a legislative decree issued by the government in the absence of a detailed mandate by Parliament, with particular regard to the duration of the ineligibility and the stripping of mandate. Second, because the Severino Decree was issued on 31st December 2012, and that was after the call for general election on 22nd December 2012. The effect was to change electoral rules on the run. Finally, and more importantly, the Italian legal system does not provide any clear rule concerning the stripping of a mandate of a sitting MP in case of supervening ineligibility. As acknowledged by the Venice Commission, the matter is put entirely in the hands of Parliament by Article 66 of the Constitution. Contrary to the government's proposition, Article 3 of the Severino Decree does not provide for the automatic termination of mandate of an MP following criminal conviction. Therefore, unlike many other European states, the stripping of mandate is not the automatic consequence of a statutory provision or of a judicial decision, nor is it a measure that the Parliament is bound to apply. The well-established parliamentary practice makes clear that the decision of stripping is one for the exclusive discretion of Parliament when performing its functions to validate the election. This discretionary power is not governed by any prescribed criteria. Moreover, the merits of the decisions are totally unreviewable. The second point I wish to address is the lack of proportionality. As stressed by the Venice Commission and by this Court's jurisprudence, proportionality is a cornerstone principle in electoral matters. And our firm position is that a mandatory minimum 6 years ban from any elective office amounts to an indiscriminate restriction of electoral rights. It is indiscriminate because it is imposed irrespective of the length of the sentence and the nature of the offence, let alone the personal circumstances of individuals concerned. In the instant case, Mr. Berlusconi was sentenced to serve 1 year term of imprisonment and 2 years ancillary penalty of disqualification. He served the sentence in probation, and in 2015, the Court of Milan declared the extinguishment of any criminal effect of the conviction. He currently has no criminal record, and he is entitled to vote, but he cannot run for election. The Severino Decree provides no adjustment to these circumstances. The mandatory minimum duration of the restriction was introduced by the government in the absence of any direction by Parliament. It is not justified by the existence of any ground of pressing significance to the democratic order, and it clearly contravenes the principle of proportionality. The same holds true for the decision of the Senate to void the applicant's election and to strip him of mandate. The test of proportionality is even stricter in relation to such severe measures which encroaches on the preservation of the elective mandate. As this court's case law makes clear, the termination of mandate of a duly elected MP must not thwart the free expression of the opinion of the people in the choice of the legislature. The legitimate expectations of the people must be protected against undue interferences, and I refer in particular to Grosaro, but also to Cavacci versus Turkey and to Likurezis versus Greece. In the case of Mr. Berlusconi, no actual risk to the proper functioning of the democratic regime was established to exist or could be presumed. He is aged 81, and he was convicted, we say unfairly, for an offence committed back in the 90s. Since then, he has been elected as MP 5 times in a row, and he served as Prime Minister in 3 governments. The offence for which he was convicted did not relate to his conduct as an MP or Prime Minister. There was evidently no actual necessity to void Mr. Berlusconi's democratic election. Turning to my third point, it is our respectful submission that the limited procedural guarantees highlighted by the Venice Commission in its brief are not sufficient and were not fully complied with in the present case. First, it is our firm position that those minimum guarantees would be completely meaningless if the final decision is entrusted to a political body which is not independent and impartial by definition. The court's case law is clear in this respect, and I refer in particular to Grosaro, but also to Podkolskina versus Latvia, where the court stated that the finding of disqualification must be made, and I quote, by a body which can provide minimum guarantees of its impartiality, end of quote. Second, not even the limited guarantees required by the Venice Commission were provided in the applicant's case. Notably, he could not be represented by a lawyer before the Assembly of the Senate, and the final decision was taken by an open vote in violation of the Senate's rule of procedure. My last point relates to the absence of any review of the Senate's decision. This in itself also amounts to a clear breach of Article 13 of the Convention. There is no dispute that the applicant did not have any remedy against the decision by the Senate to strip him of mandate. The imposition of such a severe measure cannot be left without any independent review. This is all the more so, whereas in the present case, termination of mandate is not automatic, but requires a discretionary decision by Parliament. The Court has repeatedly emphasised the need to ensure an effective remedy against decisions adopted by political bodies in electoral matters resulting in the stripping of mandate. And I refer, for instance, to Paunovic and Milivojevic versus Serbia and to Offensiva Tinerilor versus Romania. The remedy must be such as to offer minimum guarantees of impartiality in order to avoid any abuse of power. This position has been consistently upheld by the Venice Commission in the past and also by the OSCE. In this respect, the Italian legal system is unique in the European landscape. In those very few states where Parliament enjoys discretionary powers, provision is made for subsequent review by the Constitutional Court, as in the case of Lithuania and Turkey. The same applies to the majority of the European states where an implementing decision by Parliament is required, for instance, Albania, Bulgaria, Croatia, Germany and Portugal. In many other states, such as Bosnia, France, Austria and Greece, the decision to strip is entrusted to a judicial or independent authority for the very purpose of avoiding any possible abuse. The risk of political abuse and arbitrariness is not remote or simply theoretical. In fact, this court has already found in several cases that the Italian Parliament acted arbitrarily, and I refer, among others, to Cordova versus Italy. The principle of separation of powers does not obviate the need for an independent review of Parliament's decisions. Such a review is necessary to protect against undue interference with the legitimate expectations of the people and of their democratically elected representatives. Thank you very much, Madam President.